Welcome to The Fine Print, the podcast where we explore the law, its impact, and the people who shape it. I'm your host, Rudelle, and today I'd like to welcome Mr. Arvin Lee, distinguished partner at a 112-year-old Singaporean law firm with a specialization in energy law. Obtaining degrees from Harvard Law School and the London School of Economics, he has represented clients in high-stakes disputes across energy, commodities, and technology. He also serves as an arbitrator and adjudicator with leading institutions worldwide, and shares his expertise as an adjunct senior research fellow at NUS Law, bringing a truly global and valuable perspective. So, Mr. Lee, to start us off, why did you choose to specialize in energy law, and what kinds of matters fall under this area?
Right, thank you, Rudelle, for the kind invitation. Pleasure to be here. For your question, I think I'll answer the second part first, which is to unpack what constitutes energy law. And to start that off with some context, have you heard of vividness bias?
No, I haven't.
Okay. Vividness bias, I think it can be best explained by thinking of an actual scenario. When you decide on a course to take or which university to go to, what are the criteria that you have in mind?
I think just the course, passion, maybe the campus.
Okay, yes. So for you, these are the vivid factors, right? For some people, it may be the name of the university. So these are the big ticket items, right? As for smaller items, well, maybe not smaller, but there are factors such as transportation, etc. These are things that people do not really think of. And for example, if you were to go look for a job, people think in terms of salary. That's the driving force, rather than whether there's cultural fit, etc. So it is a kind of what is called a heuristic that the brain has to make decisions. So we tend to overweight certain things. And what has been now termed as energy law, I would say there's a big degree of vividness bias inherent in it. Most people, when they talk about energy, think largely in terms of oil and gas as well as renewables, and that's it. Oil and gas largely because of perhaps large-scale mega disasters, oil spills. So that's always in the news, right? And you hear how bad oil companies are, that's always in the news. So oil and gas is one big prong of it. Renewable energy, well, we are hearing about energy transitions. We're hearing about how climate change and the way we're going is not sustainable. And green energy is the energy of the future. A lot of times when people talk about energy and energy law, they have renewable energy in mind. And there are, of course, other forms. Coal isn't given much attention, right? Coal is a poor cousin. No one really thinks about that, but it's also energy, right? There are different factors. There are different regulatory regimes, contractual regimes around that. So I would say, if we were to go across the whole spectrum, 30 minutes will never suffice. So let's just go with this vividness bias and just focus on these two, oil and gas on the one end and renewables on the other. And that also happens to be the two prongs of my practice. So I'm going to use this tool as the focal points for your podcast today. Then coming back to your first question as to why did I choose to specialize in energy? In some sense, I did not choose energy. Energy chose me. Oftentimes as a practicing lawyer, especially when you're a lawyer who has to go out and get business yourself, you don't really get to choose the kinds of work that come your way. A lot of it depends on which clients come to you. So for renewable energy, I got started off in 2017 when this German lawyer who was practicing in Vietnam set up his own firm, and he introduced me a client in the renewables sector. And this client ended up giving me 4 instructions, 3 big arbitrations, and 1 transaction, which was $87.5 million debt refinancing.
Wow.
Yes. How did I come to the attention of this German lawyer based in Vietnam? It was back in 2013 when I first knew him. I was then running the China department of the Singapore International Arbitration Center. One of his law firm partners heard that I was going to Vietnam on a holiday, and he said, "Would you mind meeting my partner there? He's got quite a bit of deals and he needs to put in arbitration clauses. He wants to find out more about SIAC. I know it's a holiday, so don't feel obliged." And I said, "It's okay. I like to meet new people." So I went and spent the afternoon with him in his office, and he remembered me, and 4 years later when he had this client, he came to me. And this client is a major player in renewables. The controllers are French, and the work that I've had from them has been quite interesting. Then from that, I got on to other renewable energy developers coming through as clients. On the oil and gas side, it's something similar. I still remember I was in the Philippines on a business development trip, and I did not get any work for that 4-day trip from the Philippines. On the last day, I got a call from my ex-Harvard classmate who's Taiwanese. And she said that her ex-schoolmate's father runs an oil trading company and they have an arbitration in Singapore. They are being sued for $6.6 million, and would you be able to assist? And I had a chat with them. 2 days later, I was out in Taipei. The client flew me out. And I did that. The opponent was one of the global big 5 commodities trading houses. So that added to my street cred. And for the arbitration, I got it shaved by 50% to $3.3 million. And then we continued to exert pressure through other legitimate means, I must stress, to achieve an ultimate settlement that my clients were satisfied with. So because of the street cred that I got from that, that brought other clients my way. So that is the long answer to your question.
Wow. Well, thank you so much for sharing your journey, just entering this field. It really does look like energy law chose you and that it's meant to be.
I like to think so.
And it's nice to see that your peers come back to you as a friend, as a partner, just for their legal work.
Thank you for saying that. Yes.
Of course, with your extreme amount of experience, I'm sure that, it's something to look forward to when you have such a credible lawyer on your case.
Thank you.
And thank you also for teaching us and probably some of the listeners about vividness bias as well. Something new that, you learn every day.
Right.
So building on that and energy law and your different types of clients, what's the biggest legal risk that energy companies often overlook?
Right. Let's again unpack that question a bit, because the moment you mentioned biggest, now we're back into vividness bias territory. So we are thinking of the big macro level structural risks. There's a contradiction in terms in that question, because major companies that are exposed to such risks will never overlook this. Why? Because they have armies of lawyers advising them. So if you are thinking of these such big macro level risks, very few are overlooked, if at all. It's the smaller risks that are overlooked that cause some of the bigger problems, which I'll go on to speak about. But let me just take you up first on biggest legal risks. So some of, I think, the most prominent legal risks that people hear about these days is climate change litigation. So, for example, Shell was sued in both the Dutch courts and the English courts by climate change activists. The way these activists gain standing, or in Latin, locus standi, to sue, in order to start to commence action in court or in arbitration, you must have standing, which means you must have proximity, you must have a reason. You cannot be a stranger, some busybody, right? The law requires standing. So the way these climate change activists gain standing is they buy small stakes in the large energy companies. So they are officially shareholders. And the law gives shareholders an avenue to commence litigation against the company, either directly or in the name of the company. And that's called a derivative action. Yes. And then Shell was very prepared. So, for example, in the English courts, the climate activist investors sought to commence a derivative action on the basis that the directors had failed to set appropriate emissions targets, and in doing so failed to manage associated climate change risk. And they categorized this as a breach of the director's duties of care and skill, as well as the director's duty to promote the success of the company, both duties of which enshrined in the English Companies Act. They ultimately failed. And, well, again, that comes to the point about them being staffed by armies of lawyers who can see to this. So now, these big risks are usually not overlooked. But of course, having said that, I'll just add a gloss to contradict what I just said as devil's advocate. These climate change activists can be very smart. You can attack a company directly, and that is avoidable. That risk will not be overlooked. There's a Chinese saying, a spear that is wielded in the open, you can duck it, dodge it very easily, but a hidden sword, you can never guard against it. There are some what you call hidden ways as well. So one way is to attack the ecosystem in which these energy companies operate in. So these climate change activists have put pressure on the financiers of the energy company, hoping to cut off their funding stream. So, for example, you have got Saudi national oil company Aramco. Their financiers were the subject of a UN complaint to the effect that they had failed to achieve certain treaty obligations enshrined in domestic litigation. So that's one way in which these energy companies bear legal risk indirectly. So what will happen is that once the financiers are targeted, feeling the pressure, they will then be a lot more circumspect in how they finance, who they finance, and even if they do finance, they will just add a premium. Yes. So that's a legal risk that happens and a bit harder to guard against. Yes.
Yeah. That's quite thought-provoking on how just a simple activist might be able to take action against larger firms like Shell in your notable example.
Yes.
And how they kind of interplay with negligence and energy law. And, you see the intersection of so many different facets of law come together.
Yes.
So considering these challenges and risks, how do you see the role of lawyers in the global energy transition?
I suppose by energy transition, you mean the move from fossil fuel, oil and gas, coal, through to renewable energy. Is that what you mean by energy transition?
Yes, like how the energy is just developing with our world.
Yes.
Maybe the change from non-renewable to more renewable sources, or just promoting sustainability in general.
Yes. I think that I first have to start by saying that there still are a sizable number of players in fossil fuel, and a good number of major law firms and good lawyers are still working on that. Now, I do work in renewable energy, as I mentioned earlier, but I also mentioned I do work for fossil fuel, oil and gas companies. So I would first, again, like to set the context by saying that it is quite important to be realistic about what is the situation. There is a move, of course, towards increasing use of renewable energy, but big bulk of good lawyers are still very much involved in fossil fuel. The next point I want to make, again, for the audience who are enamored by the idea of working in energy transition, you have to be realistic about the fact that lawyers are largely decision takers rather than decision makers. I'll give one example. So the Paris Accord, it was negotiated by teams of very experienced and expert lawyers. Good product came out. And Trump, with just one stroke of his pen, signed America out of that. Right. So now that's something, whether a country is a signatory to the Paris Accord or not, is not really up to the lawyers, right? It's up to a lot of other people who are the decision makers. Another example, in some Asian countries, by law, there is still a requirement of base load that makes up the power in the national grid being from a certain source. And it's quite common to find coal taking up 10-20% of that. The reason is that influential and powerful companies and families who are in the coal business have huge lobbying powers, right? So even as the well-meaning lawyers within the legislature may want a greater proportion of the energy constituent mix to be made up of cleaner sources, these entrenched powerful companies that are in fossil fuel still have a lot of ability to lobby legislation, to lobby lawmakers and shape legislation. So that's, the dynamic that is ever present. But I would say that, once you have set it in context, there is still a lot that lawyers can do as enablers, as advocates, as gatekeepers. I mentioned the Paris Accord, the provisions was shaped by lawyers, right? So lawyers do have big role in driving the content of treaties, of legislation, of policies, transition-friendly. And you have got lawyers, when acting in deals, being able to influence the content of contracts. It's quite common for contracts nowadays, especially those that's underwritten by major multilateral type investors like the Asian Development Bank, the World Bank, to contain ESG-friendly clauses. So, for example, a contracting party to a deal that is being financed by one of these entities would have to give an undertaking, for example, that in their employment of laborers, they will observe certain standards. So, no child labor, for example. Yes. And in the purchase of technology and machinery, they will give preference to certain cleaner technologies, for example. Otherwise, the deal will not happen. Or rather, the financing to the deal will not happen. These are clauses that lawyers can help shape to the extent that many of these are, the commercial reality is that if you are doing a deal in a relatively undeveloped place and the contracting party that's based there, it may have lots of good intentions. It may want to, but the ground realities forbid it from doing so. There are labor unions that they have to not get on the wrong side of, for example. So there's always workarounds, right, that can be afforded. And it's up to the lawyer who's drafting the deal to tighten that workaround to the extent that's only necessary, right, and no more.
Yes.
Yes.
It's interesting to see the power dynamics play out and how sometimes non-renewable companies still hold power in terms of forming legislation that may, benefit them. However, it's also fascinating to see the role of lawyers and how they also possess a bit of power, and maybe collaboratively that power can become a bit stronger and develop into something where one day lawyers also have the ability to affect regulations to an extent. So to dive a bit further into globalization and just our ever-changing world, with technology changing the sector, how will AI or digitalization affect energy law and regulation?
Yes, I mean, quite a bit of this is gazing into the crystal ball because AI is still, in the overall scheme of things, very new. So what I say may be proven or disproved by events 5 years later. So I've got to caveat that by saying that I'm not the biggest authority. But I think that there's a couple of big areas that AI would impact on. The first is grid resilience. Now, what is the grid? The grid is the network made up of power producers, right, that then supplies energy to the consumers, electricity rather, to the consumers. So every country, they would have what's so-called a national grid. Grid resilience is a key thing because if there's an external shock, for example, and the grid doesn't function, I mean, it's disaster, right? So grid resilience is one key area that is always at the forefront of not just energy companies' concerns, but politicians' concerns. I mean, you can imagine if, the electricity is unstable. And yes, the politicians can't do anything about it. They're not going to stay in office for very long. Within the drive to make the grid more resilient, I mean, there's a few aspects. First, you have your day-to-day operations and systems planning. Then you have your investments into these systems. Then there are customer-facing applications. I mean, the simplest one, I don't think you're being asked to pay your family's electricity bills yet, but if, the day will come when, you may be asked to do so, and then you have this app on your phone that tracks and allows you to make payments on the spot. So there's this apps, as well as the grid system, hardware infrastructures, monitoring and security. And all these are driven by technology. And once they are driven by technology, you can see that AI certainly has a big role in enhancing all these aspects that I spoke about that's driven by technology. So for example, pricing. One of the things that sometimes surprises people is that energy is priced in half-hour blocks. The reason is very simple, because energy cannot be stored. It's current that passes through. So the price can change every half hour. So that is something that surprises many people.
Wow, yeah.
Yes. And that illustrates that, where it goes to is of course then very important. It goes to the wrong place where it's unutilized.
Yeah.
That's waste of the electricity. So AI is able to allow for better predictions to be made as to energy consumption patterns, at what time, in what region is energy more needed, so that more energy can be supplied there, routed away from places that need that lesser extent for any particular period. So that helps with resilience immediately, because energy is not going to the wrong place. It is going to the right place. So that's one area in which you'll see, AI affecting provision of energy. And coming to energy law rather than energy as such, I just wonder whether, given that AI is capable of doing so, and AI is an iterative loop, the more it is used, the more intelligent it gets, would it one day be negligent if a power producer or a grid operator fails to use AI? Right? It's just like, in law or legal research, AI can be used. Of course, if it's used wrongly, you end up citing non-existent cases that's gotten quite a few lawyers into trouble before. But it does not mean that you then throw out the baby with the bathwater, because it is still very good at trawling through huge swaths of information and narrowing down to a few core themes that are really useful in a very short time and with very little manpower. Now, law firm A uses that. Law firm B does not use that and puts 10 associates on a file just to get the same information, and they spend 100 hours. And then they bill for 100 hours, 10 associates bill for 100 hours of their time, right? I mean, there could come a day when some client will then say that it's overcharging, right? Even though that work has been done all along by, actual live human beings, warm bodies, right? So now, you translate that to the energy context. Grid operators, as well as the operators of every particular constituency of that, if they don't use AI and the grid is less resilient, could it lead to them allegation that they are negligent? Well, that's a question the law will have to answer sooner rather than later. So I think that is one big area in which you see AI play out in energy law and the standards that energy law sets.
Yeah, from politicians using AI to control their nation's electricity, or whether it just be a random citizen, using AI to pay their electricity bills. And the whole idea of grid resilience, as well as how AI can not only be applicable to energy law, but it may also have the capabilities to replace human labor in law. For example, crafting research work or framing, formatting documents that replaces labor. And I think that's quite a prevalent point that you've brought up, and maybe something that the future has to be wary of. So finally, what guidance would you offer to young lawyers looking to build a practice in this field? And what do you feel are some of the key skills lawyers need to develop in order to work effectively in energy law?
Sure. Okay. So I think that for guidance, we could tie it down to a simple, catchy rule of thumb. There are 3 C's that you have to embrace. First, embrace curiosity. Second, embrace complexity. And third, embrace conscientiousness. So 3 C's: curiosity, complexity, and conscientiousness. Why do I say that? So that ties in with the key skills that you asked about. Now, I would say that, well, given that we are quite short of time, there are 4, I think, that would be quite crucial. First, cross-border thinking. Many of these, when you work in energy, in both transactions as well as in disputes, it is cross-border. Buyers of electricity and sellers of electricity, buyers of oil and gas, buyers of sellers of oil and gas could be in different countries, right? Renewable energy projects, the project site may be in one place, Vietnam or Philippines, for example. The financiers could well come from the US. The developers may be from continental Europe. The contractors could be from Korea, could be from Japan, right? And there's a whole chain of contracts that come with it. And the party that wins a suit against, when you have a suit between parties in these value chains, the party that wins would then may have to go to a different country where the counterparty's assets are to enforce. So the ability to think across different governing laws is very important. And the key challenge for lawyers is that lawyers are schooled largely in one legal system. They may then go on to acquire foreign qualifications, but the way they think will always be tied to the place of their primary legal training. And it is very important to understand that in a world order that's shaped by cross-border flows, it's not good enough to just be tied to thinking through one legal system. I give an example. I sat as arbitrator on this dispute between buyer and seller of certain energy commodities. The buyer breached the contract by not opening the letter of credit. The buyer was in a Middle Eastern jurisdiction. The governing law of the contract followed the law of the seller. And interest is very usual claim under that governing law. But when you have a Middle Eastern jurisdiction, which is based on Sharia law, interest may well be considered haram. That's in Sharia, in Islamic terms, forbidden. Entire arbitral awards have been known to be refused enforcement simply because there is an award of interest which is forbidden in the jurisdiction where enforcement is sought. So it was something that I had to be very careful around. At the beginning, claimant's lawyer had concerns that I was being too careful because under the governing law, interest was clearly allowed, right? But when you go for enforcement, it's a public policy of the place where enforcement takes place that is paramount. Now, a lawyer that is conversant with the governing law that allows for interest must be very sensitive, when they are dealing with ultimate enforceability in a place that does not. So that's the first thing. Second is to be able to review contracts with both rigor as well as an eye for commercial logic. The commercial logic of the transaction that a contract purports to capture is very important. Who pays what for what value in exchange, right? That's the commercial logic. Who bears what risk? Who is best placed to bear that risk, and how the risk is allocated is also part of that commercial logic. And a lawyer with no commercial sense would never be able to figure out how to draft a contract that doesn't end up in trouble subsequently. Risks may be misallocated, right? They don't push back hard enough or misallocated risks. So that's one way risks can be misallocated. Who pays what in exchange for what? I mean, without commercial sense, a lot of value can be left lying on the table. So that's something that lawyers must guard against. And in order to do that, they must be as conversant in the commercial logic of the transaction as well as their principles. So it's not enough just to study the law. It is important to be commercially savvy. Then when these deals end up in dispute, the disputes lawyer must be able to review the contract as well as the surrounding circumstances, again with an eye on commercial logic. And it's very important to review a contract in its entirety. You may see a clause in some place that supports a position that you take, but if you don't read through the whole contract, you'll find a contradictory clause somewhere down. And many of these contracts, contracts are not perfect. They are done under real world pressures. Many contracts, you see the kinds of, when you're in practice and you see the contracts, your first question will always be, who on earth drafted this? Right? And the thing is that people who draft contracts day in, day out will understand why these. Sometimes they are not outright errors. Sometimes they are just manifestation of very delicate compromises, which are unworkable, but everyone wants to try to make it work. So, it's very, you come up with a structure that's very unwieldy, very delicate. So, that happens in order to push the deal through so that there's a deal or deal signing. And deal signing pressure is real. I was once instructed to coordinate a deal. It was one of the first One Belt, One Road projects, where One Belt, One Road vehicle was injecting $50 million into an entity where my client was a controlling shareholder in, and my client wanted the deal to go through. The third is an appetite for complexity. You must like complexity. You must like dealing with things that's always evolving, always different, and one single concept with many manifestations. So I mentioned earlier that pricing of electricity can take place across half-hour blocks. Then there is the converse. There's what, have you heard of fit-in tariffs? FITs? Fits? No, okay.
No.
A fit-in tariff is the rate that the government of a particular country is willing to pay electricity producers for per unit of energy. And countries that are seeking to bring in more renewable energy developers, they will increase the FITs as to make it more worthwhile, more attractive for these foreign developers to come in. It's usually expressed as price per kilowatt hour of electricity. So that is then a fixed rate, right? And if you're a junior lawyer working across two different contracts, one fixed and one that's dynamic, you must have the ability to be able to juggle two mentally in your own mind. Otherwise, you'll end up drafting wrong provisions for the one or the other. And the fourth point is to know the fundamentals of a particular sector. So, for example, trading of oil and gas, right? The very shipping itself, you may have heard of terms like FOB, CFR, CIF, etc. They do mean something. They usually, there's a lot of things, but if I were to summarize in one sentence, they allocate costs as between the buyer and the seller. Cost of freight, cost of procuring insurance, right? So these are very fundamental. And whether or not a buyer is entitled to certain costs or a seller is entitled to certain costs, that is something that is crucial. And a lawyer who does not know the fundamentals is going to get it wrong. So, for example, FOB, contrast it with CFR. FOB stands for free on board. On an FOB system, taxes, duties are to be borne by the buyer rather than the seller. If it's CFR, it's contract and freight. These duties are to be borne by the seller rather than the buyer. And when President Trump announced tariff hikes, over the weekend, I had a call from this client with a contract. Now, this client was a seller and he had an FOB contract. So under FOB, as I said earlier, it is the buyer rather than the seller that is responsible for duties. But there was an additional clause that put it upon him, the buyer, to bear all duties. The lawyer who drafted it obviously did not understand the concept of FOB and failed to guard against the inconsistency. So he was in a pickle because on the one hand, he intended for it to be FOB, and, but the lawyer let slip that particular term. So that's an example of what I mean by the fundamentals being very important. So I think I've covered all my 4 points.
Well, it's so eye-opening to hear the different facets that make a skilled lawyer as an energy lawyer. And it's a very clear breakdown of your 4 points, having cross-border knowledge and understanding about contracts, which ties into complexities. So having an appetite for complexities, as well as knowing your fundamentals, as well as your idea of the 3 C's.
Yes.
It really breaks it down very easily for our listeners to get a gauge of this aspect of law and to understand more about the different types of cases that may arise. So that's been such an enlightening discussion. And thank you so much for your time and insights, Mr. Lee. And to all my listeners, court is now adjourned. See you next time on The Fine Print.